just want to frankly remind you guys that the courtroom is now live.
You look like you're ready.
I just bring so much more than I really need, but if you don't bring it, you're gonna need it.
I know, I brought my laptop, which I always like have the record right there.
Oh, yeah.
So,
Yeah.
I drove from
I'm
campus.
old school with the notes on paper still.
Yeah, I have my notes.
Yeah, and then when you try to go lighter, it's like, oh, I don't have that on. You really use it right. Bring everything, right?
The guys were in there talking about it. They're like, we always get her on the other side when we file a case.
Oh, really?
Yeah. So do you just do appeals? For how long?
About 10 years now.
That's awesome. Yeah, that's all I do too.
Yeah.
But do you do all sorts of appeals or just civil appeals?
Really everything that our lawyers do, so it's mostly civil.
No criminal? just never get around to it. I'm too busy.
It's a huge application. It's not.
Well, I've looked for myself, so it's like, to set aside time to do all that stuff, is raising a kid pretty hard. Well, I wish you all the luck. It's a hard, I meant on the test. I wish you luck today too, but on the test, because it's a hard test.
Yeah.
If not after the bar, never sit for another test.
That's what I said. So I said the only test I'm going to take is a pregnancy test after the bar. So the drive wasn't too bad.
Yeah, I came over last night, so I don't mess with Orlando traffic. So I'm very thankful.
I went around Orlando. So I'm going to go back through Orlando though.
presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, state of Florida, and this honorable court.
Okay, you may be seated. Thank you. Good afternoon. Welcome to the 5th District Court of Appeal, our oral argument session for this afternoon. Before we get started, let me introduce the judges on the panel. Again, I'm Judge Boatwright. To my right is Judge Adrian Soud, and to my left is Judge Jordan Pratt. We have 2 cases on the docket this afternoon. Each side will have 20 minutes to argue their case. Appellant is allowed time for rebuttal argument, so when you come forward, please let us know how much time you would like for rebuttal. The first case we have on the docket today is case number 24-003, Robert Bovel versus the state of Florida. So, Mr. Fletcher, are you ready to proceed?
Thank you, Your Honors. Good afternoon, Your Honors. Charles Fletcher for Robert Bovel. I would request a 5-minute rebuttal, if that's okay.
Okay, yes, sir. Okay, you may proceed.
Thank you. Your Honors, the 6th Amendment to the United States Constitution guarantees a criminal defendant effective assistance of counsel. And that assumes that each participant, the lawyer on that side and the lawyer on this side, know the rules of evidence. And in this case, we have an attorney who had a virtual treasure trove of evidence.
So, counsel, let's assume, for the sake of argument at this point, deficient performance. Let's say if you can establish that element. Just focusing on the prejudice prong of Strickland, there's a couple of facts that I think are more difficult for your side. The first is the number of shots fired when the deceased was on the ground. As I understand it, the testimony was not controverted by the defendant, correct me if I'm wrong, but that there were several shots fired after the decedent was on the ground. And the second fact that I'd like you to address is that the defendant began firing before, according to his testimony, before he even thought that the decedent was reaching for a firearm. So, given both of those facts, can you point us to case law that would establish that it is a triable issue for the jury to determine whether a shooting is justified under those circumstances, even assuming that all of the facts that you contend the attorney should have brought before the jury had been brought before the jury? So all the threatening messages or the messages that the defendant characterizes as threatening, all of that stuff, let's say that had come in. Can you still address how we get over the prejudice prong given those 2 facts that I just gave you?
Yes, sir. As to the number of shots, this was, Mr. Bovel had been receiving messages for a couple of weeks. He knew that this person was a gang member. He knew he associated with gang members. He knew he was well armed. He had been to his house and seen his gun collection. He is walking out of a bar at night. He has been told that Mr. Sullivan is in town. He sees a Snapchat where Mr. Sullivan is holding an AK-47, makes a statement about being in Ocala. And with that mindset, he gets, as he's walking out, he gets attacked from behind, and as he starts, and it's dark out, and as he starts to turn, Mr. Sullivan starts to turn, he sees him start to reach in this area of his body, and he produces his firearm and starts shooting.
Was that the testimony, though, or was the testimony that he fired 2 rounds and then saw the decedent reaching for what he thought was a firearm?
I think you're correct. However, with the level of threats that he received in his mind, that was admissible to show his state of mind. It wasn't used, but assuming it was used, he had a right to stand his ground, to act in self-defense based on what he thought. And frankly, I think that's much more of a jury question.
So can you point us to a case where an appellate court in Florida has held that it is a jury question whether a shooting was justified when the entire justification for the shooting is threats, or the kind of messages that we have here, and then a single punch to the head? Can you point us to an appellate decision that establishes that it can be justifiable use of lethal force under those circumstances?
I can't judge, but you refer to it as a punch to the head. What Mr. Bavel experienced was sort of clobbering. He doesn't know if it's a firearm that hit him or a punch to his head. What he knows in his mind is that this person is after him. He's come from another city to find him. He offered somebody $1,000 for his location. He gets hit from behind in the dark. And to me, there's that scintilla of evidence that was admissible to establish that I get to act in self-defense and fire first.
Mr. Fletcher, following up on Judge Pratt's question, though, but I think what he's getting to is the same thing that causes me concern. It's not the first two shots. It's the fact that independent witnesses, and I went back and reviewed the trial transcript, say that they pursue the victim for 25 to 30 feet, then he stands over him and then fires his gun 6 or 7 more times until the clip was empty. That's much different than, that seems to be a change in course and self-defense that you're trying to argue. I mean, why did the jury not get that right? Even with these messages being placed in, how does that change? We're not talking about a couple shots where he shot him initially. It's he followed him, and I think the shell casings were spanned over like 50 feet. So, I mean, we're not talking about a situation where he's scared, fires a couple shots, and goes the other way. He then follows after him while the guy is on the ground and unloads the gun into him. So I don't quite understand your position.
Judge, I think it's easy to sort of stand back and evaluate a person's actions and make points like that. I think to be in his shoes, to be a reasonable person in his shoes, as a jury would look at him, he thinks this guy is armed, and after those 2 shots, there is some dispute as to how far they traveled in the parking lot. Shell casings may have been here and there, but that's the nature of shell casings. When they get ejected, they bounce all over the place.
They go 50 feet from your standing still?
Judge, I don't have any expert testimony on that, but if you're on concrete, they can go a pretty good distance. Secondly, Judge, I think it took a little while before the crime scene was roped off and those things were located and then documented as to exactly where they were. So if there were some outliers there, they could have been kicked by people. This was a crowded bar. Shooting happens. Everybody goes running all over the place. So I'm not sure.
But it was about your first point as to not filing the motion to dismiss on the stand your ground motion. The trial court's reasoning, one of their reasonings in denying the post-conviction motion was strategic nature of the attorney, that he did not want to divulge his defense. You would agree there's situations where you decide not to take depositions because you don't want the other side to understand what the testimony is going to be, especially with the defendant's testimony. So you don't really address that in your brief. You talk a lot about you don't really address the trial court's decision, but when a trial court finds that something is strategic, why is that not enough to affirm on that issue?
Judge, I don't know how an attorney who doesn't know the basic rule of evidence in a self-defense case and who says to himself, I can't use any of this evidence, so here's my decision, how we can say that that's a viable strategic decision. He used his flawed knowledge of the hearsay rule to come to that decision.
Well, do they discuss authentication? The judge relied on the fact that it couldn't be authenticated. I thought trial counsel also said that below too, correct?
Judge, that was stated. However, that was after the attorney admitted in court on the stand, as I was questioning him, that he did not know that these things were not hearsay. He mentioned, well, I might have had some trouble getting certain things into evidence, and I think I sarcastically said, you just asked the judge to issue
I thought there
a
was
subpoena.
quite a bit of testimony about him, about authentication between him and the state. I thought there was quite a bit at the hearing. Am I mistaken on that? I mean, the judge even puts it in his order. He discusses this wasn't just hearsay, it was authentication. Were you able to prove at the trial court that these could have been properly authenticated?
Judge, they could have been authenticated because you can subpoena Facebook, you can subpoena text messages, you can subpoena records from Snapchat, those things.
Were you able to do that?
And they had
Were you able
photographs.
to do that at the hearing to get them in? Did you subpoena them to get those in?
I did not, Judge, but I had them because the investigator had obtained them for the attorney. So we had them.
So even if we assume that the statements are admissible under an exception to the hearsay, that they're authenticated, you still have the issue where the trial court in its order purported to find as a factual matter that those statements were non-threatening. And, my understanding of the law is that, there's a general test for what constitutes a threat, but it's also a very fact-intensive inquiry. So, such that in some cases you might be able to say as a matter of law, a statement is or is not a threat, but in other cases it might be a jury question. Do you agree? Is that generally how this works? And if so, tell me why this is not a case where the court could say as a matter of law that these statements were non-threatening.
I think if you take an individual statement out of context and you ignore Mr. Bavel's testimony and everything that was happening with Mr. Sullivan, you can say, well, I don't see a threat in that statement. But in a self-defense case, where the only defense, because he's standing over him when he's arrested, the only defense was self-defense. What was going on in Mr. Bavel's mind was of the utmost importance.
True, but the test is whether the defendant reasonably believes that deadly force is necessary to prevent imminent death or great bodily harm, right? So reasonableness, that smacks of the legal, right? But also of the factual, of the application of law to fact. And I guess my question is, the court in its order found that these statements did not constitute threats. What is our standard of review for that? And what is your best argument to say that that should be a jury question rather than a judge question?
My best argument for why that should be a jury question, Judge, is in the context of the accusation that you stole something from me, I'm going to come get you, and then the repeated texts, Facebook messages, phone calls, threats, telling friends of Mr. Bavel, I'm going to come get him, sending pictures of an AK-47, all of those things have to be taken into account. And and it's a jury question, so a juror is sitting there saying, with all of that input, am I being reasonable by acting in self-defense and shooting? And we think that he was being reasonable.
Did any of the messages, and I've looked through all the messages, did any of the messages, I don't want to make sure I didn't miss anything, say anything like straight up come out and say, I'm going to shoot you, I'm going to kill you, or are these just kind of the way your client kind of perceived these messages?
There is no message that says I'm coming and I'm going to shoot you.
Okay.
But in the context, Judge, a picture of Mr. Sullivan holding his AK-47 and, bitch ass niggers, I'm going to catch you in traffic. The other posts, shoot me when you see me. If that's not saying, you better shoot me first because I'm going to shoot you, that's how Mr. Bavel interpreted that. It should have been placed before the jury, and it wasn't because the attorney thought it was hearsay, and it wasn't hearsay.
Was your client at all communicating at any point with the victim?
He had received text messages from the victim and phone calls.
I know your client was also communicating back, was he not? Phone calls, text messages, and the like?
I think he responded. I don't think he went out of his way to call Mr. Sullivan.
Okay. What do we make of the guilty verdict on the lesser included? He was charged with second-degree murder with a firearm. Jury found him guilty of the lesser included manslaughter with discharge. What do we make of that?
Well, what I would like the court to say to itself is that if the jury had had all these other little pieces of evidence, the jury would have gone a step further and found that his actions were justified based on the number of threats, his knowledge, the gang signs. He knew the guy had a whole treasure trove of guns at his house, the AK-47, which, by the way, was found in Mr. Sullivan's car just feet away from him. So I think the jury would have taken that extra step. They were looking for a reason. They were not provided with that evidence, so they stopped at manslaughter.
So is the contention then that the jury credited his testimony that he feared for his life, but believed that his actions were not justified and that they were unreasonable, but if your additional evidence had come in, you think that the jury would have additionally made that additional step to find his actions reasonable and his fear reasonable?
I do, Judge, and here's why. When he was being cross-examined, he started to mention posts and something like that. Mr. Avon, the prosecutor, said, woulda, shoulda, coulda, and bulldozed over him and didn't let him answer. So I think the jury, had they heard more of that type of evidence, they would have acquitted him.
A follow-up on Judge Soud's question on the trial transcript. I think it was in the trial and the defendant's testimony. Wasn't there 14 calls between the two of them and then 11 were made by the defendant to the victim? I think the state points that out. Is that, I mean, that's correct. That's from the defendant's testimony, correct?
That's true. That's correct, Judge.
Okay. I mean, is that a feature in this? I know Judge Soud raised it. Is that a feature in us affirming this matter?
I don't believe it should, Judge. And I apologize. I was thinking about the testimony from the 3.850 hearing when Mr. Babel testified. I don't remember us talking about him making phone calls. But I don't believe so, Judge. I don't believe so.
Okay. All right, you're at your rebuttal time?
Yes, sir. Thank you.
May it please the court, my name is Chris Davenport and I represent the state of Florida. I will start with the factual finding by the court that this was a strategical decision to not introduce these purportedly threatening messages. Now, if he had a message there, the defendant said, pointed to send him a picture of a gun and said, I'm coming for you and I'm going to get you. That would have been probably not a great decision to not admit that. But when you look at
were the text messages admissible?
Were
the posts, all the threats, were they admissible?
They were, I would think they could go to the state of mind if they were found to be relevant. They still have to show that they're relevant. The judge found that picture of them holding gang signs, I mean, it's these kids they do this, which in my day was hang loose.
So, counsel, you can look at anything in isolation, but I mean, if you look at the mosaic, right, if we stand back and give this a 30,000-foot view, right, he offers Damon $1,000 to provide him the location of the defendant, sends the defendant's mother a message on Facebook that says, your son has taken something that is very valuable from the wrong group of people. I'm hoping he would consider returning what's missing before the end of the week so we can all work together to prevent escalation in the wrong direction. Sending pictures of the mother's old home, asking Damon if he's hot or cold. Damn, Bobby, you harder to find than a word I won't say here, that old child support. You see my snaps, come out and play. If you see this word I'm not going to say, anywhere in the city, bang my line, even if he's in church. The picture of the AK, and then shoot me first. I mean, if you add all of these things together, right, why is it not a jury question if this had come before the jury, right? So assume, for the sake of argument, that we disagree with you, we think that counsel should have brought these before the jury. Why would that not be a jury question? Why can the court, sitting at a 3850 hearing, make the finding that those are not threats?
Because that's the court's role in a post-conviction motion. We're not talking about a jury anymore. Now we're talking about second-guessing what trial counsel did at the trial. And what the court has to evaluate is, was this a reasonable strategy? Not would I have done that? Not is this the best lawyering I've ever seen? Not I'd give him an A+ at trial. It's, is it reasonable? Is the adversarial system working in this case? And he acted reasonably in deciding not to do this. And the reason counsel was aware of these, the investigator found this stuff, and counsel testified, I decided not to do this for a couple of reasons. Number one, it's not always easy to authenticate social media stuff. You have to find somebody to say, I found it on this page, and then you get the question, well, the state can say, well, you don't know who else posts to his page, and you get into all of this muck, right? And more importantly, counsel said, pardon?
That sounds a lot like weight, potentially.
But we're not talking about what the jury would have done with this. I'm not talking about prejudice. I'm talking about deficient performance, because the trial court found that this was a reasonable strategy. And the counsel most importantly said, I had the defendant, he's going to testify. And when you look at how he testified at trial, he said, the victim called me and said, I'm going to kill you when I find you. all of this stuff.
Sure, but it's a lot different when you've got self-serving testimony from the defendant, and then when you see it, on a Facebook or
Right, but
Snapchat.
what
Now,
you
my
but
question,
well-
though, it was more geared toward one of the reasons why the court found it was a permissible tactical decision is because the court said, look, these messages aren't even threatening.
Right.
Would you at least, let me rephrase my question. Is it appropriate for the court, in the context of a 3850 hearing, to be making the finding as to whether or not these messages, when placed in context, are threatening?
Absolutely.
And how can the court do that?
Absolutely, because they have to consider whether or not counsel acted reasonably in deciding not to introduce this stuff.
Sure.
Because he was aware of it, and he decided not to introduce it. And he explained why. And if I could analogize this, if I say, I found a giant spider in my shower this morning and it was terrifying, people are going to be sympathetic to that, right? If I show them a picture and the spider's like this, that changes everything. Now all of a sudden my testimony about how scared I was is very different, because now you have, well, see what these messages really are. So the defendant can say, the defendant did testify, I was scared of him. He directly threatened me. He said, I'm going to shoot you. And I knew he had guns. Never any question that the victim had guns. Everybody agreed to that. Never any question that the victim was really mad that he thought the defendant stole his gun. Never any question that he was looking for this guy. We had the defendant testify about it, and we had the person who actually got the $1,000 reward offer. He testified about that too. Yep, he offered me $1,000. This is my buddy. He really wanted to find this guy. The question is, does that make him so scary that you can use deadly force? And while the defense presents the victim as this scary gang member, I would submit, when you look at the evidence in this case, number one, if I'm going to kill somebody and I'm a gang member, I probably don't tell his mom, hey, tell him to give the gun back. You probably, if I'm going to kill you, I'm probably not writing a message to my mom saying, I really want to de-escalate this. If I'm a gang member who's threatening to kill this guy, outright threatening the whole time, and I see him at the wing house and I come up before him, first of all, I'm going to have my gang members there. Second of all, I'm going to bring my gun. His gun's in the car, unloaded.
This sounds like a great jury argument, but again, what my hang-up is I'm just trying to figure out whether or not the judge can sit and say that we have confidence in this jury verdict, even notwithstanding the fact that these messages were not presented to the jury. Because as a matter of law, the judge sitting here says no jury, or at least no reasonable jury, would find that these messages might be threatening.
That's not what the test is, though. The test is no reasonable attorney would say, I don't want to take the chance of trying to get these in when I have much better testimony from the defendant himself. And the judge reacted to these social media posts by saying, really? First of all, let me say that the assault weapon where he's sleeping with the gun, he didn't send that to the defendant. He posted it on Facebook. If that's threatening, then everybody who enjoys having an assault rifle, and there's a lot of people in our society who do, who post pictures of themselves or send Christmas cards with them posing with their guns, they're automatically a threat to me now because they own an assault rifle? That's not how this works. It has to be, the legislature hasn't said, gee, anybody with a gun, you can use self-defense against them. That's not how this works. It has to be an imminent threat. You have to be afraid that you are going to imminently be subject to death or great
But
bodily
to be fair, I don't
harm.
think the defense theory is that he had a picture of a gun. I think it's a lot more than that. It's the messages and all of that, right? But so one of the things, though, that came out, and I think it's mentioned in your briefing, is that there was testimony at the 3850 hearing that one of the factors in the decision not to pursue a stand your ground motion to dismiss was the notion of political pressure and a belief that the court, even if the law required the granting of the motion, simply would not grant it because of political pressure. Would you at least agree that that would not be a permissible or cognizable defense tactic, right? We shouldn't presume that courts are going to fail to follow the law because of political pressure or the racial composition of the defendant and the deceased. Would you at least concede that?
I don't concede that you shouldn't consider whether or not a judge is going to grant your motion before you stick your defendant on the stand to testify, and then the state's going to use that if your motion's denied.
But if one of the reasons why the defense attorney believes that the court won't grant it is because even though the motion may be well taken under the law, that the court is going to decline to follow the law because of political pressure. I mean, should we allow defense attorneys and say that it meets the standard of, performance for the attorney to prognosticate about a trial court's unwillingness to follow the law? Because essentially that's what that argument is, and I just don't see how that could be a permissible defense tactic.
First of all, I don't agree that that's what they're arguing. I think they're arguing when you file a motion like this, you're going to have to put your client on the stand, and then the state's going to be able to cross-examine him, and then if this doesn't go well, the state's going to have that prior testimony to use to impeach him at trial. So all of a sudden you're stuck with what he said at the stand your ground hearing, no matter what happened there, because he's going to look inconsistent otherwise. I think one of the reasonable things that an attorney does is decide whether or not that particular judge is going to go for this or not. With the facts that you have and the evidence that you had, this guy called a bunch of experts, no one could help him. He knew that, politically it's not an easy thing to do.
Why is that politically not an easy thing to do?
Because he's going to get, they're elected trial judges. I mean,
but why is it politically uneasy? What politics prevail in this case against the granting of the motion?
And even the defendant's mom testified that there were a lot of shootings at the time. People are worried about crime. You're going to let this guy off. There's always political pressure in these kind of situations. And these are factual determinations. The judge has to make a factual determination here. And the trial counsel was well aware of what these facts are. And he says, is this judge going to kind of go out on a limb and say, yeah, I'm going to grant these. These get reversed sometimes?
I want to follow up on Judge Pratt's point, though. Are you standing here suggesting that it is a reasonable, acceptable strategy to assume cowardice of the trial judge because of pressure?
Absolutely not.
Okay, so we're clear on that.
Right. And I'm not saying that that the trial counsel can say, well, the judge isn't going to follow the law. That's what we have appeals for.
Okay, because that was part of the testimony, wasn't it?
The testimony was, but I think there's a difference between saying this judge doesn't follow the law, so I'm not even going to bother, and saying this is a tense political time. It's a hard political decision.
Brass tacks.
And we don't have the facts to back it
Brass
up.
tacks. The inference that I got from the testimony, there was a mention of the Black Lives Matter movement, right? The inference being the defendant is white, the deceased is black. The trial judge wouldn't grant a stand your ground motion based on the racial composition of the defendant and the deceased. Would you agree that if that were defense counsel's purported tactical decision, an assumption that a trial court will not follow the law because of the racial makeup of the defendant and the deceased, that would be wholly inappropriate?
Absolutely.
Okay.
If that's what
we don't presume that trial courts are going to fail to follow the law because of that sort of political pressure.
No, and if that was his only reason is, gee, we have a white defendant and a black victim,
Did the judge
so I'm not going to
did
follow
the judge even make a factual finding about that?
No.
Below?
He found that it was a reasonable strategy to not file this overall, because if that was the only factor, and let me be crystal clear here, if the trial counsel had said this judge won't do it because it's a black victim, that's not an appropriate thing, because then if that's what's really happening when we have appeals, that's not how you look at it, and the court can't assume they're not going to follow the law.
And that's the clarification I was after,
Yes.
because that was starting to go down a path, because I know that the defendant and his mother both testified that was one of the reasons suggested to them by defense counsel as to why it was why a stand your ground was not filed. Did defense counsel ever recognize such a thing?
The defense counsel said that there was a lot of political pressure at the time, and considering if that would have been it, he considered everything. It's a close case. I don't have any experts. I have to put my client on the stand. I decided not to do this.
So
that's
then,
strategy.
If there are other considerations pertinent to defense counsel, such as I'm exposing my client to cross-examination pre-trial, I am disclosing theories of defense or lines of questioning that I may undertake, I'm disclosing weaknesses if I do not have expert testimony sufficient to back up a particular position.
Right.
If defense counsel comes in and says that was the reason for his decision, and other witnesses come in and say it may have been other sort of political considerations or whatnot, is that not precisely the role of the post-conviction court to weigh that evidence and make the decision? such as he did here in denying the motion?
Yeah, absolutely. They have to, and they're considering, again, the test here isn't what a jury would have thought. The test here for deficient performance is it reasonable for counsel to make this decision? And counsel mentioned all of those things as factors. You know, if you have a judge who won't grant a motion to suppress, and it's well known in the community and they just won't do it, then you have to consider, well, do I have the facts that I can win this on appeal? And what am I doing by filing this motion? Am I exposing my case that's going to hurt me at trial? So all of those things are relevant factors. This is an experienced attorney in Ocala, which is, you know, a relatively small town. You know, they're familiar with all of that. It certainly, you know, played a factor, but he had a lot of reasons for this. And the political thing was, gee, I think this doesn't have a strong chance of success because we don't have the facts to make this work and make this judge have to.
Yeah, the political thing isn't moving me. I'll just be honest. I mean, it just strikes me as wholly inappropriate to assume that courts are going to apply politics rather than the law.
Right.
But I understand the other factors that you're saying. I mean, it seems like, you know, if we dwell on the prejudice prong for a second, you know, even assuming. You know, one question I have that I didn't see addressed in the briefs, you know, we have the discussion about the number of shots, right? If, just assume for the sake of argument, if we thought that it, you know, could have been deficient performance and, you know, perhaps even prejudicial about those initial shots, right?
Right.
Whether those were justified. But then assume that, you know, we look at the final 6 shots and we think, yeah, those weren't justified. What is the law on causation, right? You know, if a defendant would have died due to the initially justified shots, can the defendant escape criminal liability for the unjustified shots if the defendant is able to prove that those shots were not the but-for cause of death?
That's an interesting question that I am not aware of any law on that. You know, the jury has to decide whether the defendant acted reasonably. You know, the defendant admitted he killed the guy. Did he act reasonably? The guy was still alive. He was running away. He was alive on the ground when he was firing those shots. I think if he had shot him in the head initially and then emptied his clip, I think that would be an interesting legal question. You know, do those extra shots matter then? Because he
had a 13-round magazine.
Deadly force, right? Yes.
Right, and the most, you know, debatably problematic shots.
Right.
Seem to be those final 6.
Right.
Right.
Yes.
We have 7 initial shots.
Right.
You see where I'm going? I'm just curious about the state's
do.
perspective.
I think it's an interesting question in a different factual scenario, where you just shot him and killed him right away. He drops to the ground, and then you're like, and just, you know, spray a bunch of bullets, and it didn't matter. I think he used deadly force that caused the death of the victim in a reasonable manner in that situation. That's not the case here. This guy was alive and running away. Even the prosecutor, if you look at the prosecutor's closing argument at trial, he said, let's believe everything the defendant said. He was scared, he had a reasonable fear. Those first 2 shots, okay, but he pursued him and he laid on the ground and the defendant stood over him and fired. And that's murder. That's the closing argument of the defendant, of the prosecutor. I think that's right. So the prejudice prong is clearly met here. Let me go back to the stand your ground motion. The prejudice prong is met there too, because the defendant went to trial. A jury of his peers found that the state proved beyond a reasonable doubt that he did not act in reasonable self-defense.
This is very different from Boston, right? Because the jury didn't have before it the facts that defendant contends was deficient performance not to present to the jury, right? Right, when you have a stand your ground hearing that presents all of the facts, the same facts that go to the jury, yes, the jury can cure any error. I understand that, right? But here, the defense argument is quite different. It's the jury should have had more facts. And had it had more facts, it would have concluded differently. So doesn't that take us outside the Boston case?
If you consider all of this stuff together, yeah, that one claim is, you know, but you kind of combine them, because he also says, well, at the stand your ground hearing, you should have presented this social media stuff. So that's kind of combining the 2 claims. And if he had made that, then the trial judge would have granted it. Well,
you would agree with Mr. Fletcher, though, just stating that making a strategic decision. If the lawyer doesn't know what he's doing and is making legal errors, you can't hide behind strategy, correct?
Correct.
Okay.
This lawyer was, again, 22 years criminal lawyer. He said, do you understand that this, what it is to be hearsay and not hearsay? Yes, I understood that.
Assume that we believe it's legal error on both the hearsay and the admissibility issues. And assume also that we would not accept as a permissible strategic consideration the politics surrounding everything. What other factors went into counsel's decision not to present those messages to the jury that would be a permissible strategic reason?
He knew that you could get over the hearsay thing. His concerns were authentication, which is hard. And here's the thing, he didn't say, I couldn't authenticate it. You know, he's standing in front of a jury, and all of a sudden you're getting into the weeds of authentication. That's, let's be candid, that's boring, right? And you have to consider its effect on the jury. And the state's going to say, well, you don't know who posted that. It could have been somebody else. Yes, that's true. It wasn't sent to you. Yes, that's true. All these factors.
It's boring trying to do your job to authenticate things and get them into
I
evidence?
think you have to consider the value of the evidence versus how it's going to go in front of the jury. I think that is a relevant consideration. It's not the only consideration. Again, his main thing wasn't, I don't understand hearsay. That's not what he said. He said, I had the defendant who testified to these direct threats. And when you look at the defendant's testimony at trial, he said, he told me, I'm going to come and kill you. That's what he told me. And that's a lot different from, I'm looking for you. I want my gun back.
As your time is running to a close, though, and I do want to ask a question, I apologize if it runs us over just a minute. We've said a couple times, assume for purposes of argument deficiency or that it was wrong not to seek to admit those messages and the like. And certainly we understand that in oral argument we do that. But I don't want it necessarily to automatically be assumed that somehow that's the conclusion. In other words, you began to argue a couple times, and I'm saying this now because I'm going to ask Mr. Fletcher a very similar question. Deficiency under Strickland is extraordinarily high. It's not you should have done this and you didn't. And in fact, I believe you quoted it in your brief, but the deficiency must be so serious that counsel is not functioning as counsel guaranteed by the Sixth Amendment. Errors so serious as to deprive the defendant of a fair trial, producing a reliable result. So serious that it constitutes a breakdown in the adversary process that renders the result unreliable.
Absolutely.
That's the burden we're talking about.
That's the burden,
So-
and that's, yes.
And I just want us to be clear, certainly for argument we may do that, but we're not going to, well, let me speak for myself. We ask questions, but questions aren't necessarily based on conclusions we're making, but asking for purposes of other arguments, such as trial judges, such as trial counsel. We're not assuming certain things when we may ask a particular question for purposes of argument. But if I heard you twice in your argument, you're relying this on the argument. This does not constitute deficiency sufficient for Strickland, correct?
I'm relying on both. It was reasonable strategy. He knew what he was doing. He made choices. It's not our role to second guess that.
Right.
And there was no prejudice because he shot this guy 13 times,
Sure, but if we
including was
don't
laying on
find
the ground.
deficiency for Strickland's purposes, we don't even get the prejudice.
Exactly.
Okay.
But we made both is the bottom line. Yes.
I'm done.
Okay. All right. Thank you, Ms. Davenport.
Thank you.
Okay. Mr. Fletcher, your rebuttal. Okay.
Thank you, Your Honor.
Why does this reach Strickland's standard? I'm sorry to hit you right when you get to the podium, but I gave you a warning. Why does this reach Strickland's deficiency standard?
Judge, as you said, the magic words are counsel was not functioning as counsel under the Constitution. And if you don't know the hearsay rules and what is hearsay and what is not hearsay, and you make the decision, I'm not even going to try to get this bucket of evidence into evidence because I think it's hearsay, you are operating as deficient counsel. All of your decisions, this court cannot say he made a strategic decision not to enter not even to try to enter he didn't make a strategic decision. He thought it was inadmissible hearsay, so he didn't even try. He's operating below the hard deck. You have to know the rules of evidence. It's a self-defense case. The main thing in self-defense case is what's going on in the defendant's mind. And he had all that evidence, and it would have corroborated Mr. Bavel's testimony. Instead, Mr. Avon, the prosecutor, got to call him a liar and said, and all those things. But that was corroborating evidence that the jury didn't get. Mr. Bavel did not get a fair shake. His attorney didn't know the rules of evidence. He admitted that on the stand. And then he turned to, well, there might be some authentication problems. There's no evidence, there was no testimony by Mr. Pollock as to what steps he took to try to authenticate anything. And the reason he didn't take any steps to try to authenticate anything, he thought it was inadmissible hearsay. Why bother? So Mr. Bavel, in this case, has shown you that Mr. Pollock was deficient under Strickland.
So, and counsel, I'll ask you the same question I asked of your friend on the other side, just again, because I didn't see it in the briefing, but I'm just curious how I wrap my mind around this. Assuming for the sake of argument that had this stuff come in, the jury could have concluded that the initial shots were justified, but that the last shots were not. Do you know what the state of the law is on causation and whether it is a viable defense in a self-defense case to say that the initially justified shots were the actual cause of death and not the unjustified later shots? Are you aware of any case law that deals with that argument?
I'm not aware of case law, Judge, but as a defense attorney for 27 years, I can tell you that if I was presented with that fact pattern, I would absolutely pursue that defense.
Okay. Does that fact pattern fit this, or is this different?
I believe, Judge, that as this court is referring to them as the extra shots, Judge, I think without, it's a jury question, and with the jury not being advised of all of that admissible evidence, the fact that this guy carries guns, the AK-47 in the car, the threats, everything, all of that would have played into their evaluation of what was going on in his mind and why he kept pulling the trigger. And I would be remiss to not point out police officers do exactly that when they're confronted in these types of situations. So I believe he would have been acquitted by this jury, who already, without all that evidence, took that step and said he did not have a depraved mind, even though he shot him 6 or 7 times as he laid on the ground. They took that step. They said, nope, this was just an act, manslaughter. And had they had that extra evidence of what was going on in Mr. Bavel's mind, they would have acquitted him. This is deficient performance, and it's prejudice at trial. That's all I have.
Okay, thank you, sir. Okay, thank you to both of you. Well-argued case. Okay, we'll call our next case up once the attorneys have exited. Okay, our next case is Timothy Smith versus Kimberly Mayers as the personal representative of Robert Jane Mayers III. And Ms. Perry, would you like to reserve any time for rebuttal?
Yes, Your Honor. May it please the court, my name's Allison Perry, and I would like to reserve 5 minutes for rebuttal, please.
Okay, yes, ma'am, you may proceed.
Okay, this case involves, excuse me, an order granting summary judgment and a final eviction based on that order. So the standard of review is de novo by this court. This case involves a lease in between the appellant, Timothy Smith, and his deceased stepfather, Mr. Mars, that was entered into in January of 2002. The terms of the lease allow Timothy to remain in the property as long as he maintains the property.
So the trial court found that this was a perpetual lease, correct? And
Right.
then that became an illegal restraint or an unlawful restraint on alienation of the property. Am I correct on that? And so one part of the lease allows a renewal for as many years as desired, and as I understand your argument, you say, well, that at some point will terminate.
It will have to terminate upon his death or
Upon his death. What about the fact that this lease also allowed the tenant to assign this to his heirs or assigns?
Well, that's just superfluous language.
I mean, it's part of the lease, correct?
But,
So how
but
does
the
that-
lease requires him to reside there. And another point is that that's not the grounds that the court found it to be void. The court found it to be void because of term 3, paragraph 3, and paragraph 22. It did not consider the paragraph 24.
But answer my question, if you can.
Okay.
Not what you're saying the trial
If
court did.
the- okay.
If he has the ability to assign this to his heirs, and then they have the ability to assign, then doesn't that make it perpetual? Isn't it
because-
arguable it's perpetual at that point?
No, because because the term says the lease shall be binding upon and for the benefit of the heirs, personal representative successors, and permitted assignees, so it has to be permitted, of landlord and tenant, subject to
Isn't there an assignment? It says, unless this box is checked, tenant may not assign this lease or sublease in provision 9, and then the box is checked.
Box was checked.
So tenant has the ability to do that under the language
Well,
of the
it
lease,
has to be
correct?
permitted. I guess you're saying that means it's permitted. But it's subject to the requirements specifically mentioned in the lease. And in the lease, the term is that the lease is for a term of 12 months beginning on January 3rd, 2022, and ending at such time as a tenant no longer chooses to occupy the premises. So he has to occupy the premises. That's the term of the lease.
So if you assume that we agree with you on the interpretation of the lease, I'm wondering how this is still a marketable property. What would be your sales pitch?
It's not. It's like a lifetime.
To a prospective buyer, right? So
It's
somebody's going to come buy this property, encumbered by this lease, as you understand the lease, right? What is your sales pitch to the prospective buyer as to why they should buy the property and what it's worth?
Because it's only going to appreciate in value. The lessee has the motive to improve the property because he gets the enjoyment of the property while he's maintaining the property.
But the lease says that the landlord bears like the lion's share of the maintenance obligation,
Well,
and there's no rent that's paid.
Right,
Zero,
but there's
right?
right, correct. But he has to pay the utilities, and he also has to maintain the property. And
Part of his maintenance of the property is taking out the garbage, pest control, termite control, but roofing, expensive maintenances of the property fall to the landlord.
correct. But Florida allows such life estates as this all the time.
Let me ask you, if you say, does this actually meet the formalities of a life estate?
I believe it does.
Okay, do you have any legal, other than you believe, is
Well,
there any, do you have any kind of legal, any case law, any kind of statutory law that says this is a life estate? I mean, because he's paying no rent, and he pays no taxes, which usually under a life estate, you're going to take care of the taxes. So I'm just wondering how this lease, if this can be called a life estate.
Okay, this is more akin to the case where the parents left their children. Let me see. Hold on a second. The Johnson v. Gertman case, which is in my initial brief, and that's at 452 Southern 2nd, 1033. It's a Florida 3rd DCA case from 1989. It was overturned on other grounds by the Florida Supreme Court. But in that case, the grantor conveyed to their children fee simple estate of the house to their children with the condition that the children leave their share of the house to their children. So, in fee simple. So they basically wanted to leave it to their grandchildren eventually. Now, the court said the restriction was no more repugnant to the public interest than the granting of a life estate to the Gertman children with a vested remainder in the simple to the grandchildren.
So you say the trial court relied on the PV case, correct? That's from our court?
Yes.
That's from our court. And you say it does not apply
It's
here.
from the That's from the, no, that does, Gertman?
The PV case.
Oh, PV case does not apply.
Okay, yeah, but I mean, that's from our court, correct?
Yes, that's
Okay,
more
and so
important
the
because
trial
it's-
court relied on the PV case, correct?
Yes.
Okay, and why does it not apply?
Because that is for an unlimited period, because that, in that case, the lessee was a corporation, and
Did
corporations...
the PV court talk about the fact that it was a corporation?
Yeah, yes, they talked about it was a corporation, and...
That was the basis of their decision, or
that it
as...
would go on indefinitely.
Or as Judge Pratt said, dealing with the market, and I know he didn't mention the PV, but he raised the issue of the marketability of the property. Wasn't that a
Correct.
focus also of PV?
Yes, that was also in PV, talking about the marketability of the property, and also that
Was there anything
no...
in this lease that precludes the tenant from assigning, without the landlord's consent, the lease to a corporation?
He has to occupy the property, so if he occupies the property, I guess during his...
Why couldn't he set up an LLC and transfer it to the LLC and then occupy the
Because it has to
property?
be a permitted assignee, and I don't believe that
But the landlord's consent is not needed to make an assignment. And a corporation can occupy a residence, right? A representative of the corporation could live there and cut the grass, right?
That's true.
Okay, so, I mean, I'm just trying to imagine, again, going back to marketability, which, is really what the test on, restraints and alienation focuses on. I'm just wondering what the sales pitch is. Like, who wants to buy this house, right? There's a guy who lives here. He doesn't have a whole lot of responsibility. He has to maintain it other than the really big ticket stuff, so he does the small ticket maintenance. He doesn't pay taxes. He doesn't pay rent. Oh, and by the way, he can assign the lease to anyone he wants to without consent of the landlord, which might even include a corporation. Who's the buyer for that house?
Well, one, I disagree that he can assign the lease to anyone. I think that language, the language of of paragraph 24 says it's subject to the requirements specifically mentioned in the lease. And specifically mentioned in the lease over and over again is that he gets to stay in the property as long as he chooses to occupy the premises.
But he could, again, as Judge Pratt said, he could set up an LLC, assign the property to this LLC, if he was even a member of the LLC, and live in the property, correct?
I think we're losing sight of like the original intention. The intention of the lessor of this property was a stepfather who wanted to leave a property to his stepson for his lifetime.
But when we look at intent and contracts, we look at the language. He's not here to testify and tell us, what he meant, and it's not really our job, I don't think, to try to, after the fact, climb into his head and try to figure out what he's thinking. What we have are the words on the page, right? We have a lease that we have to construe. We have the supremacy of the text. We have to look to the text. The text is the evidence, the probative evidence of what the owner sought to convey. And, again, I mean, I'd appreciate, an answer to Judge Boatwright's question.
Marketability.
How is that outside the text of the lease?
Okay.
Maybe that's a different rephrasing.
Well, to get to your question on marketability, their life estates are given all the time in Florida. And Florida law permits restraints on alienation that are limited. That's the law. That's Johnson v. Gertman, 542 Southern 2nd at
I think we understand you're allowed to give a life estate. So is there any testamentary documents other than this lease that indicated his intent, either in a trust or in the will in this case, that would have indicated his intent that this was supposed to be a life estate?
Actually, the affidavit that was attached to the response from the appellant stated...
I'm talking about would have been from the testator himself, the decedent in the case.
There's a missing will, is my understanding, is there is a missing will.
So that could still be flushed out in the probate case as far as whether or not he was entitled to a life estate in this property through a will, correct?
Yes.
Okay.
Now, importantly, the court ruled that paragraph 3 and paragraph 22, they found the lease is clearly a perpetual lease, as outlined in paragraph 22, Because of the renewal and extension, the lease automatically renews and extends for another year and for as many years as desired by the tenant until the tenant, at his sole discretion, shall cancel this lease. And it says his sole discretion. So it shows that they wanted it for him, his discretion, not a corporation, not some assignee. It's for his sole discretion. So that term right there, his sole discretion, those terms together show that the intent was to give this to Timothy for his sole discretion. So that his is very important because that couldn't be a corporation, it couldn't be a she, and I believe it shows that there was no intent, there was an intent to leave this property to Timothy for a life estate.
Doesn't an assignment of a contract assign all of the rights and responsibilities under the contract to another? Isn't that what an assignment is?
If it's assignable, and I don't think this contract is assignable because of that term, and also because it says that it's subject, that the assignability is subject to all the other terms of the lease, and the terms of the lease require him to occupy the property.
Right, but wouldn't the assignee be required to occupy the property, right? Because it is a responsibility of the lessee under this contract to occupy the premises, right? And if the contract, the lease is assigned, right, doesn't that occupancy responsibility fall to the assignee?
I disagree because I believe this lease, based on the language, it's his sole discretion. He has to occupy the property, and as soon as he doesn't elect to occupy the property anymore, the lease is terminated.
Right, but
So
the his that's identified is the tenant, and someone to whom this lease is assigned becomes the tenant, yes or no?
I just don't think this is an assignable lease because of the, by him, on his term, the tenant cannot assign this lease because it's specific to him and the terms of the contract. And remember, the court didn't rely on that to reach its decision. I understand the tipsy coachman doctrine, but the tenant, subject to the requirements specifically mentioned in the lease. So the specific terms of the lease control over this miscellaneous section. It's in a miscellaneous section for a reason. It's not, it wasn't considered the heart of the agreement. And the lease clearly the lessor wanted his stepson to have a life estate or something similar to a life estate as long as he wanted to occupy that property until his death or departure from the property. So that's all I have.
Okay, thank you.
Any other questions?
All right, I don't see any. Thank you.
Thank you.
Okay.
Good afternoon, and may it please the court. Alyssa Corey of Schutz and Bowen on behalf of the landlord. The trial court correctly determined tenant's lease was void as an unreasonable restraint on alienation, or alternatively that the lease properly terminated after a single renewal term, and as a result, landlord was entitled to summary judgment as a matter of law, and that decision should be affirmed. On appeal, and as has been discussed at issue, tenant suggests that the lease is of a limited duration and takes issue with the trial court's analysis of the lease's renewal clause in Section 22.
Let me ask you, if we were to interpret the lease as Ms. Perry states, that this was just for Mr. Smith's lifetime. Judge Pratt's raised this issue. Marketability, the restraint against alienation, do you think that would still apply in this case? Let's say Mr. Smith's going to live another 20, 30 years.
Correct, and I think the closest case that kind of gets at that discussion is in Thompson versus First National Bank from the 4th DCA in 1975, where there was a lease period and then a subsequent amendment to that lease that then extended the lease term in total for 70 years. In that case, that reasonableness analysis determined that there was no perpetualness of that lease because there was a fixed ending period here. And while the tenant seems to suggest that the death would be at some unknown time a fixed ending period, that's not consistent with the terms of the lease in Section 24.
But if it were, would this then be considered a unlawful restraint of alienation at that point? If there were some fixed point, let's say 20 years, 30 years, I mean, I don't know how old Mr. Smith is, but let's say 20 years down the road. Because Judge Pratt raised the issue, as I understood, regardless of whether it's perpetual, at some point it could be so long that the marketability is affected.
Right,
I mean,
exactly.
you're not paying any, he's not paying any rent, not paying any taxes. So, I mean, is that supported by case law that a long-term lease in something in this form is still an unlawful restraint of alienation?
That's correct, because Florida follows that common law rule that unreasonable restraints are void, looking at the reasonableness of the restraint itself. So that is going to be a fact-specific case. The rule of unreasonable restraints really focuses on the alienation through the lens of the long-term effect of improvement and marketability of the property. And so we've got those public policy considerations and the idea that the free alienability of property fosters economic and commercial development.
Why couldn't a hypothetical buyer look at this property and say, you know, my general counsel's, you know, every home buyer comes with a general counsel. Joking, obviously. I know that's not true, but hypothetically, my general counsel says, you know, there's a pretty good argument this lease is really, you know, subject to renewal every year. And worst case scenario, it's only going to last for as long as this tenant lives. You know, ordinarily this house might be worth X amount, but you know, if we dock it, you know, the tenant, you know, let's say he's X years old, we think he's going to live for Y more years. Yeah, let's dock from the home price whatever we think Y years is worth. Yeah, maybe I'll buy the house. I mean, are you saying that there is no such buyer, or is that the test, or is the test, you know, that there has to be, you know, a reasonably sized market for the property, right? Because you can always find at least one buyer who's willing to buy anything, right? There's a price for everything, they say. Why doesn't this home have a price, or is the test instead that the home should have a price for a reasonable, you know, sized market?
Yeah, and I think when we're looking at the factors in PV that is instructive to your question, we were looking at a fixed term for, you know, $600, $650, $700, and then it would increase for $50. And as noted in PV, few people would be willing to purchase a property which they might never have the right to use other than to rent it at a predetermined rate. And at least in PV, there was rent that was being received. Again, the lease at issue has the potential to prevent landlord from being able to utilize the property for any purpose.
Does PV even apply here, though? I mean, appellant's counsel claims that PV doesn't apply because the lease is not to a corporate entity.
And PV may have involved a corporate tenant, but the reasonableness test that was applied originated from Englehart versus Phillips, which is a deed between a father and a son, does not involve a corporate tenant and has been applied equally to non-corporate tenants, and has been discussed by Judge Pratt. The lease involves and allows for permitted assigns without restriction. That could lead to tenant potentially assigning his interest in the lease to a corporation. Tenant essentially asked this court to ignore Section 24 and the permitted benefits and assigns. But indeed,
why is this not just a life estate? Why shouldn't we just treat it as a life estate?
As an initial matter, the life estate construction of this lease was never presented to the trial court. The way that the tenant framed that argument below was allowing for lifetime renewals. Lifetime renewals under a lease is certainly much different than purporting that the lease conveyed a life estate. This has been discussed about the probate case that's ongoing and what may, you know, shake out in that case.
The probate case is still proceeding?
The probate case is proceeding, but the tenant dismissed its claim against the estate a week before trial. So there won't be any further determination on that basis. And when talking about the life estate, the Johnson case that was discussed is just factually distinguishable in that discussion about a will and the validity of the surrounding circumstances of that conveyance. Here, agreements to devise property by will must include sufficient consideration. There would have to be an analysis of whether no rent and limited maintenance is sufficient consideration. It has to be in writing and contain the same formalities of a will in writing to witnesses. None of those conditions are present in the lease at issue, and this can't be construed out as a life estate, even if it's deemed to be preserved as presented before the trial court.
Just going back to the nature of the applicable test, if we could, as a court, hypothesize an eclectic buyer that would find some value in a property, would that be sufficient to defeat a unlawful restraint on alienation claim, or does there have to be a higher showing that, it's more than just a single eclectic buyer, but there's some sort of market? And how do we gauge the size of that market? I'm just curious, what is the test that we're applying? How do we flesh that out? Because it occurs to me that, there may be, for any given eclectic property, one eclectic buyer that might find some marketability in its title. And I'm just curious what your take is on the test. What's the test that we're applying?
Yeah, so the test for looking at the validity or invalidity of the restraint, as we discussed, looks upon the long-term effect of the improvement and marketability of the property. And then once that effect has been determined, we've got all of the factors on time, how much rent, is it fixed, is it floating?
No, I understand all that, but I'm just, marketability to whom, right? If you can find a buyer, one eclectic buyer, is it marketable? Or do you need more than one eclectic buyer? Do you need, and then what is the size, right? I mean, there are homes that are marketable to everybody. There are homes that are marketable to a few. There are homes that are marketable maybe to only one or two, right? What is the size of the market that needs to be shown?
And as this test has been applied, then they say common sense should dictate whether it's reasonable or unreasonable. Testing
So
out.
the test would be reasonableness under PV,
Right.
would it not?
Yes. And so, we're looking at whether the restraint as analyzed through the lens of the conditions would be reasonable or unreasonable. So looking at your hypo, Judge Pratt, I would say if there's one eccentric buyer that is okay with a corporation taking over this property, for a term as long as it chooses to occupy the premises and until at its sole discretion cancels the lease, sure, there might be one buyer out there that agrees with that. But when we're looking at the validity of the lease and whether the terms are perpetual and present an unreasonable restraint on alienation, we've got to exercise that common sense application. And then, of course, here we're looking at two alternative bases. The court, determined that the lease provisions are void because of this perpetual nature, but also we have to look at the additional basis where there, say there is, we talked a lot about intent in the argument and what was the intent of the stepfather, who passed 9 months after this lease was executed. We have to say the trial court looked at this in the light most favorable to the tenant, construing the lease as providing for a 1-year renewal term as opposed to being void. So the trial court in the alternative determined at most if the lease renewal provision is construed to not sufficiently establish that clear and explicit right of indefinite renewals, that the lease was properly construed to entitle tenant to 1 renewal period. If there's no further questions.
Okay, I don't see any. Thank you, ma'am.
Thank you. This court should affirm the grant such removed judgment.
Ms. Perry, any rebuttal, ma'am?
Yes, Your Honor. Okay. So Iglehart is where the Florida Supreme Court, or this is from the order granting summary judgment, and the court found that Iglehart where the Florida Supreme Court found that this type of lease gives the landlord little incentive to make improvements on the property and puts into question whether the landlord would even be able to sell such an encumbered piece of property to a third party. But Eagle Heart had to do with a deed restriction, a repurchase deed restriction. So he could never sell the property without having to give the right of first refusal to, it was the father.
All of these cases, though, as Judge Soud, really focus around this reasonable element. That's
Yes,
correct?
the reasonableness.
Okay.
Now, remember, Florida law permits restraints on alienation that are limited. So limited like lifetime estates, which are done all the time. As long as a restraint is not repugnant to the public, and here it would not be repugnant because it is like a life estate. And that's the Johnson v. Gertman case that I already cited to. And this is clearly an intent of the stepfather to leave his stepson a property to live in during his lifetime, and this court should reverse.
Thank you.
Thank you so much.
Very well argued case by both of you, and we are finished for the day, so we will stand in recess.
Thank you. Tough on me, not so much on you.